Let's go live button. So now let's wait for the stream to fire up across the internet. We do multi-stream here. We're on Facebook and YouTube and even Twitch. Sometimes it takes a little bit of time for all of those different platforms to get aligned, but it looks like we're now live and ready on YouTube. So let's get going. Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gruler. I am a criminal defense attorney here at the R&R Law Group in the always beautiful and sunny Scottsdale, Arizona, where my team and I, over the course of many years, have represented thousands of good people facing criminal charges. And throughout our time in practice, we have seen a lot of problems with our justice system. I'm talking about misconduct involving the police. We have prosecutors behaving poorly. We have judges not particularly interested in a little thing called justice. And it all starts with the politicians, the people at the top, the ones who write the rules and pass the laws that they expect you and I to follow, but sometimes have a little bit of difficulty doing so themselves. And so that's why we started this show called Watching the Watchers, so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency back down upon our very system with the hope of encouraging some meaningful change. And we're grateful that you are here and with us today. We're getting close to wrapping the week up. We're on day 4 of Derek Chauvin's trial, and we've got a lot to break down here. Not a real eventful day in terms of moving the needle when it comes to sitting a jury, but we do have some interesting things that we can talk about. Number one, the judge brought back the third-degree murder charge. So I want to break down what happened there. And this judge actually got a little bit fiery, I would say, when he was trying to explain his prior decision to get rid of the third-degree murder charge. Court of Appeals brought it back, and so he wanted to make sure he went on record and explained it, because the Court of Appeals sort of kind of implied that he was acting erroneously, and the judge said, no, we're not going to let that stand. So I want to show you what that looked like. Then we're going to get back into jury selection. There was only one additional juror seated today, which is more, I think, the pace that I was expecting. I think it was on Tuesday, we had jury selection start. We got 3 people seated on that day. Yesterday, Wednesday, we got another 2 seated, and today it was only 1, unless there's any last minute things that, actually, no, it's over, because I finished watching it. So we only had 1 additional person today, and that was about the pace I was expecting. When we had 3 and 2, I was thinking, man, this is going a lot more quickly than I was expecting, but we'll see if this pace continues or if it ramps back up tomorrow. But we do have a new juror we can talk about. Juror number 6, a married Hispanic man, now joins the panel. So we'll break down what happened there, and then I want to spend some time talking about some of the people who were disqualified today, who were not selected, because there were some interesting things that popped up. We have a black female juror. She was eliminated, and there was a back and forth that took place over this because the prosecutor really wanted her on the panel. The judge tried to rehabilitate her. The prosecutor tried to rehabilitate her, and then when she was disqualified, the prosecutor came back and said, listen, I even object after the fact. So the prosecutor made his arguments. The judge heard his position, disqualified the judge, and then they went on a break, and they came back after the break, and the prosecutor still wanted to object to it. I mean, he really wanted this person on the jury. And so, we're already seeing people on both sides of the aisle claiming that this whole thing is about race. Some people are already unhappy about the makeup of the jury, and it's not even done yet. And so I want to show you what this looks like, because I think that we're going to see more of this. We're going to see a lot of people crying foul as it comes to race relations because this woman was black. We're going to see a lot more of this. And I just want to show you behind the scenes. I don't want to make this too political or too racial, but I just want to show you what is going on, because you're going to see a lot of headlines out there saying that this whole thing is racist and all this other stuff. And it's like, listen, the judge went through a series of questions, and I think it's important that we break down why this juror was disqualified, and I think it goes beyond her race. So we'll get into that. It's going to be one of those shows. Then we're going to change gears. We're going to talk about Cuomo. He's back in the news. There's, I think, a 6th accuser now. There's going to be many more. I lost count. But the point is, this was something that is now potentially criminal conduct. It has been referred over to the Albany police. They're going to be investigating it. It sounds like, just due to the fact that this new allegation involves some physical touching. Some of the others didn't, but they kind of did. We saw the picture with his hands on the woman's face, and on and on and on. There was another woman who claimed kissing. Now, this is the first allegation where the police have basically responded and said, yeah, we're looking into this specifically for criminal charges. And so we'll see where that one goes. Lastly, very short segment, we have an interesting case from a Florida woman who was accused of assisting in the murder and dismemberment of her daughter-in-law. Her charges got dismissed. So I want to show you that story as well. So we got a lot to get to. Going to jump right into it. A couple quick reminders. If you want to be a part of the show, we're going to be taking questions as we go throughout the material today. You can ask those questions over on our platform at watchingthewatchers.locals.com. You got to support the show if you want to go over there, but we're going to be taking questions about any of these issues that I just discussed. So if you want to go over there and ask one, that's where to do it. watchingthewatchers.locals.com. You can also get a copy of the slides that I'm about to go through, and you can meet some pretty great people and support the show. So head on over there if you want to check that out. And then we are at the end of the broadcast. We're going to jump onto Clubhouse. There's a link in the description below wherever you're watching this. And so we're going to do a live Q&A. Yesterday we went, I think, until 9 o'clock. So we're very good, very in-depth discussions. Want to invite you to be a part of that if you are on Clubhouse. All right. So let's get into the news. The big story of the day as it relates to the Derek Chauvin trial is the reemergence, the reinstatement of the third-degree murder charge. This story comes over from the Star Tribune, as I've mentioned. They're doing very, very good work on covering this trial. Very comprehensive. We had some good graphics that we saw yesterday, and so go check them out if you want to get news. A lot of the other news sites that I've been seeing are really sort of overly politicizing it, in my opinion, and this is sort of the best place to get a first-hand account of what's going on. Here they say, fired Minneapolis police officer Derek Chauvin will again face an additional count of third-degree murder in the death of George Floyd. The judge, in his case, reinstated the charge today on Thursday. And I'm going to show you the judge's explanation for this. We have some clips that we're going to go through, and I fixed the audio, I think. Judge Peter Cahill, his ruling followed a series of appellate decisions that revived the count before the jury selection was to resume. The reinstatement came after the state Supreme Court on Wednesday, so this was yesterday, rejected a request by Chauvin to basically appeal a court of appeals ruling that said that they could bring the charge back. So this is kind of procedural mumbo jumbo, but if you recall, early on in the case, there was a third-degree murder charge. The judge dismissed. They said, no, it's only if it's a threat to multiple people. Here, it was just Chauvin versus Floyd, right? It was just two people in this interaction, and because of that, because there were not multiple people, that doesn't necessitate, there's no probable cause for a third-degree murder charge. So the judge here, the same judge, Peter Cahill, dismissed that charge. The government wanted to bring that charge back. They took it up to the Court of Appeals. Court of Appeals says, yes, you can bring it back. Court of Appeals didn't enter an order yet, so it wasn't, this underlying judge, Peter Cahill, was sort of having a question whether it was precedential or not, or there was a lot of issues going on here about the prior case that they were basing the appeal off called Noor. A lot of complexities. I'm not going to get into it. Point is, Court of Appeals said they could bring the charge back. Then Derek Chauvin and his defense team appealed that to the Minnesota Supreme Court. Supreme Court said, we're not accepting the appeal. Therefore, the Court of Appeals ruling stands. And then the judge today said, okay, well, I have to follow the Court of Appeals ruling. And so this third-degree murder charge is coming back. He said, I am granting the motion because although these cases are factually different, that is Noor in the case before us, I don't think there is a factual difference that denies the motion to reinstate. When the intent is directed at a single person, then third-degree murder may apply. And so this was the argument, right? Because if you look at the third-degree murder charge description here directly from the statute, you can see this says, third-degree murder, perpetrating an eminently dangerous act and evincing a depraved mind. Here it says by perpetrating an act eminently dangerous to others. And there's an S there, right? Meaning multiple people, but the Court of Appeals said, no, it's okay. Single acts directed at a single person fall within the gambit of the third degree. Accordingly, I am bound by that. So the judge is bringing it back, basically as I was suspecting was going to happen. If you recall, when we did our original Defending Derek Chauvin video, I covered defenses for all three of the charges because I thought it was going to be coming back, and here it is. So the same defenses, I think, apply. There was a lot of back and forth over this, and I think it was instructive. Let's take a look at more from this article. We see here we've got, before Cahill ruled, defense attorney Eric Nelson argued that Chauvin's case is different from Noor's because there was no inherently dangerous factor like a gun. So in Noor's case, which is what the appeal was sort of challenging, there was a gun. In this case, he's saying this is not the same case, said Chauvin's defense lawyer, Nelson. He says, factually, there is no instrumentality here other than Mr. Chauvin's knee, which is not inherently dangerous. And to be fair, I think that the judge actually sort of agrees with the defense on this, but his hands are a little bit tied. He can't, he may agree with them, but the Court of Appeals said otherwise. So he's got to follow their precedent. And he was very sort of, he seemed a little bit agitated to me, quite frankly, when he was going through his explanation about why he was going to bring this charge back. And this is a big deal. This is three charges. this is one of three. This is a big deal. And so I wanted to spend a little time about it. Now, Attorney General Keith Ellison, who is the chief prosecutor in the case, he's very happy, expressed satisfaction with the restored count. The charge of the third-degree murder, he said, in addition to manslaughter and felony murder, reflects the gravity of the allegations against Mr. Chauvin. We look forward to presenting all three charges to the jury. Adding the third-degree murder to Chauvin's case gives jurors the opportunity to convict him on a count sandwich in between the current charges, second-degree murder above and manslaughter below. So you've got second-degree murder here, then you've got manslaughter down here, and then you've got third-degree murder here. And that's that eminently dangerous charge. Second degree is more of the felony type of murder because it was committed in the course of a felony, the allegation here, and that the felony was the assault of Chauvin having his knee on Floyd's neck. All right, so the third-degree murder charge was coming back. I want to show you this. I want to break this down a little bit, but we have to introduce a new party to the case. Here we have this new individual who came in, Neal Katyal. You can see down here at the bottom left. So the government's team is just burgeoning. They're adding new and more and more people to the case so that they can each sort of present different arguments. And today, this Neal Katyal, he was the person who was arguing about the third-degree murder charge. And he was very, very good, very familiar with it. I think that his arguments were very persuasive. He was essentially saying that, these cases are, or these different charges are similar enough that if you bring in the third-degree murder charge, you're not going to have to sort of, have a whole new trial because it's closely related. It's sort of different degrees of murder. You've got the second degree, third degree, and then manslaughter. And he's saying, okay, so we're just bringing the third degree in. They were already preparing for the second degree. They were already preparing for manslaughter. So we're kind of just bringing a charge right in the middle of them. So shouldn't be that big of a deal. It's not like a totally unrelated charge, right? If he's being charged with murder and then they wanted to also get him on child abuse, that's totally unrelated, right? The defense would be like, where did that come from? And so he was very persuasive in that regard. Now, from a defense perspective, this is also a pretty big problem if you're a defense lawyer. You've prepared for two charges. You're in the middle of jury selection. You haven't even started trial yet. You're scheduled to start here at the end of the month, but jury selection may go another week or so. And so you've already sort of begun the trial and already seated jurors on your panel before you knew what the charges against your client were, or against you if you're Chauvin. So this is something that the judge is going to have to address tomorrow. He said earlier this morning that he would be inclined to grant a continuance from the defense. So if they say, hey, we need more time to prepare our case, he said he's inclined to grant that, but they have to show that they would be prejudiced. They would have to be unduly prejudiced by a denial of that continuance. So in other words, if the judge said, I'm not going to grant you a continuance, or you have to proceed as expected with the current, all three charges, the defense, Chauvin and his team, they have to show that it would be to their detriment. They would be harmed by not granting a continuance. If they have to go forward, it's going to be a violation of due process. They're going to lose some of their ability to win the case because this is all happening too fast. And so many of us think about the right to a speedy trial, but you also have to, we want trials quickly, generally speaking, because we don't want people to sit in custody. We don't want these charges to linger over their minds or their lives for eternity. That's why we have a guarantee of a right to a speedy trial. But in some cases, the defense, they need more time to prepare their defense. And so we're going to see what Mr. Nelson does tomorrow morning to address it. We also, if we go back to our chart here, we can also see that we added a sixth juror, and so we're going to talk about him a little bit later, but the other parties largely remain the same. Haven't seen anything from these two down here. They did stand up on the first day and sort of introduce themselves, so they're still here, but haven't seen them actually speak yet in court, but I could have missed it. And so let's learn a little bit more about this fellow. His name is Neal Katyal. He is a Supreme Court lawyer, law professor, extremist centrist, whatever that means, former U.S. acting attorney, solicitor general, all views mine, no one else's, and you can see he works over here at Hogan Lovells, which is where some other individuals who are on the government's team also work. Neal Katyal, he's the former acting solicitor general, and you can see over here he was on apparently Colbert at some point. In December 2017, American Lawyer magazine named him the litigator of the year. He was chosen from all the lawyers in the United States. Age 49, already argued more Supreme Court cases than any minority attorney. Recently held the record by Thurgood Marshall. So this guy's basically a badass attorney, right? He's crushing it, and he presented that way when I heard him speak. He was orally argued 41 cases before the Supreme Court, 39 of them in the last decade, 2016 to 2017 alone. He argued 7 cases in 6 separate arguments at the Supreme Court, far more than any other advocate in the country, nearly 10% of the docket, which is just crazy. And he's got a pretty nice pedigree as well. So let's take a look at some of his educational background. So Doctor of Law, Rutgers University, 2019. Those are honorary degrees. He's got the City University of New York, 2018, another honorary degree. JD comes from Yale Law School, and he got his associates or his bachelor's out of Dartmouth College. So, pristine, top of the heap when it comes to those schools, and he's obviously got a background. So we've seen a lot of this. The government is bringing in some major heavy hitters, and so we've got sort of as we can see from our chart here, it's looking a little bit lopsided. If you're the defendant, you're going, what the heck is going on over here? We're at Yale, Harvard, whatever, wherever they're all from, right? Super A team coming up there against Chauvin versus Eric Nelson. So, and his assistant. So, I think Eric Nelson's doing a great job. We'll see if that can continue, and I'm sure it will. So we know a little bit about him. Let's take a look at what the judge is talking about here. So I wanted to play this clip just so you can get a little bit of a sense of this judge. I feel like I've been talking a lot about the other people right now, but this judge, you can tell he's getting a little bit irritated because this ruling just came down from the Court of Appeals. And in their order, it sounds like they were sort of pointing the finger back at the district court. They were pointing it back at this judge and saying, hey, if you would have read the rules, Judge, maybe you would have been able to understand that this was the right thing to do from the beginning. And the judge here, you're going to see him push back. He goes, wait, hold on a minute now, Court of Appeals. I did look at the rules, by the way, and there's nothing in there. And so he just gets a little bit, which I like. I like that. I like when judges are very self-assured. They sort of know their place in the courtroom. They own the courtroom to a certain extent. I don't like people in law who sort of just get steamrolled over by somebody else if it's outside of what's right to do under the law. We have ethical rules, we've got procedural rules, we've got precedent and all of these things, but still sometimes people will just get steamrolled by their supervisor. We see this with prosecutors all the time. We'll have a conversation with a prosecutor and we'll say, hey, there's no probable cause here. This is a due process violation. This is a right to counsel violation. And they'll say, well, yeah, I think actually that's a good point. This officer kind of screwed it up. Then they go and talk to their boss and they come back down here and they say, no, this is why, in fact, it's not actually a problem. And my boss said X, Y, and Z, and we're going to revoke the plea deal if you don't take it. And you go, come on, guys. Like, I know you have the power and the authority to do that, but you are doing something that is contrary to the interests of justice. In my opinion, they start off that way, but they get steamrolled by their bosses. Same thing happens with judges. Judges will be involved in a case like this. The appeals court will come back down, kind of slap them on the hand, and they'll go, oh, yeah, I'm sorry. Yep, I'm sorry. And then suddenly their whole demeanor changes throughout the entirety of the trial. Absolutely not happening here. Peter Cahill just said, no, I didn't do that. You're mischaracterizing what this lower court did. You're entitled to do that. You're the Court of Appeals. I'm going to follow your mandate. But at the same time, I want to go on record and explain what really happened here. And so my hats off to the judge. I'm very happy with his sort of demeanor and the way he carries himself in the court. I think it's admirable. So here he is. Let's listen to it again.
All right. With regard to the state's motion to reinstate, the court is going to grant the motion to reinstate, and I want to go a little bit at length addressing it. In reading, obviously, the Noor opinion came out, and it was very clear that I disagreed with it, said so, denied the motion initially because of my disagreement, but not without first checking to see if I was duty-bound to follow it as precedent. And now, based on the defendant's appeal, this Court of Appeals has made it very clear, yes, I was bound from the moment the opinion was filed, and I accept that. I even agree with the decision in State v. Chauvin that their opinions have precedential value immediately. And I want to explain why, because I did not believe so before. My concern is how the Court of Appeals got to that position. They stated in their analysis that the plain language of the rule says that precedential opinions take immediate effect. That implies that this court disregarded plain language in the rules, or at worst, was too lazy to look up the rules. Neither is the case. Upon reading the Noor opinion, realizing its application to this case, this court immediately turned to the rules to look for plain language as to when opinions that are marked as precedential have in fact that precedential effect. We found silence, not plain language. I think the Court of Appeals reaches too far by saying there's plain language in the rules. there is silence. There is not language prohibiting or saying that it is entered at judgment or that it takes effect immediately, but it is silence. And I think what the Court of Appeals has inferred from the silence is that opinions take immediate effect when filed. I accept that.
Oh, so if you're not a lawyer, then you may have watched that and you're like, what the heck is Rob doing back there bouncing around excited? That's because this stuff doesn't happen that much. This judge just had an appellate court basically tell him, you did something wrong, you should have read the rules, and he just went through and said, hey, I did read the rules, there's nothing in the rules, all right? Now, I know what you guys did up there, you knuckleheads. You said because there is no rule that you can draw an inference from the fact that it's not being addressed, and you can interpret that inference, you can interpret the fact that the rules are silent on that issue and justify some further cause of action. He's saying he just read that implication that there's nothing in there a different way, which I think is totally appropriate. And so for the court to suddenly turn around, the appellate court to turn around and say, well, if you would have read the rules, and this judge comes back out and says, all right, we're going to follow your opinion over there, Mr. Appeals, but let me be clear, I did read the rules. There's nothing in there about them. So let me tell you a little bit about how you came to your legal conclusion that I'm going to follow. So I like that. Little bit of spice from this judge, which is good. We have another clip here from him.
I'm granting motion because
this is where he's explaining the motion or what he's ruling on. All right, here it is.
I am granting motion because although these cases are factually different, that is Noor and the case before us, I don't think it's a factual difference that weighs in favor of denying the motion to reinstate because of the language of Noor. Noor is very clear. When intent is directed at a single person, this is a legal principle that they've established now as precedent, then third degree may apply. Single acts directed at a single person fall within the gambit of murder in the third degree. And as I said, that was part of their holding. It is not dicta. Accordingly, I am bound by that. I have to apply the rule. Even though they are factually different, I have to follow the rule that the Court of Appeals has put in place, specifically that murder in the third degree applies even if the person's intent and acts are directed at a single person. I disagree with the state that the defense has forfeited any other grounds, and so that's why I'm permitting the other grounds to be argued, but I do not find them availing here. First of all, the ex post facto, the statute has not changed. It has remained the same for years. It was the same as it is today as it was on May 25th of 2020. And finally, discretion. It is an abuse of discretion standard, but discretion can be abused. And I think when my ruling, both in the fall and lately, in denying motion to reinstate, was based on a legal principle alone, not on the facts of the case. It was the facts of the case that this appeared to be an act directed towards a single person, and on that legal principle of the single person rule, this court granted a motion to dismiss for probable cause, denied the motion to reinstate. But now that the Court of Appeals has said in a precedential opinion, specifying the single person rule applies to third degree murder, I feel bound by that, and I feel it would be an abuse of discretion not to grant the motion. As a last comment, there are cases, in fact I have myself, I think it was trial before last, on a criminal sexual conduct case. The state came in on the day of trial asking to add an assault in the first degree charge, and it came out of left field. There was really no notice that that was going to be important, and since it was an assault in a criminal sexual conduct case, we were talking about different intents, different foci on the acts that were committed. And I denied the motion to amend because I thought it did. It came out of left field, basically. And this case is different. This charge has not come out of left field. It was originally charged. I think the defense has been aware that the state will take every opportunity to try and add it back. The remedy is not to deny the motion to reinstate based on timeliness. It is to grant a motion for continuance if the defense can prove to me they are prejudiced by this ruling. So, murder in the third degree is reinstated as originally charged. In this case, this is not a decision as to the other three defendants who are set for trial at a later date, and we'll address that later. Mr. Nelson, anything? Are you ready to proceed?
I'm ready to proceed.
All right. No other requests? All right, we'll then proceed. We're going to take a...
All right, so they take a break. There was a lot of argument about this morning. Pretty good argument. We saw from the new addition to the government's team. We also saw that Eric Nelson went up there, and he was basically making three arguments. The first one we heard a little bit about. The second one was this is an ex post facto law. If they sort of are making something criminal after it already happened and then applying it backwards to the defendant, that's not allowed under our Constitution. And the judge said, well, the statute didn't change all that much. It's just sort of how we interpreted it. And the prosecutor also came back and said, well, it's closely related enough that it shouldn't even be considered something outside of the focal point of the trial. We already know that basically the arguments are going to be mounted around causation and showing what the true cause of death was. And so you can still use those same defenses even for the third-degree murder charge. So they took a break. They got that settled. Third-degree murder is coming back. We're going forward on all three charges. Eric Nelson tomorrow morning is probably going to argue that they need more time, a continuance. We'll see what the judge wants to do about it because trial is not even scheduled to start until the end of this month. And he may just come back and say, whatever the rules of criminal procedure are there in Minnesota, I'm not familiar with them enough to make a snap judgment on this, but that they're not prejudiced. And so he may not grant them a continuance. So we'll see where that goes. They took a break. They came right back in and they went into jury selection. And this is where the jury stands. So we're up to 6 here today. Added one new addition, number 6. We're going to learn a little bit more about him. Let's take a look at the jury demographics as we need to do, because this is just something that is relevant in this type of situation. So now we have 3 white individuals and we have 3 people of color. And I'm using that term because that was used in the Tribune article. So we have number 2 is a person of color, female. Then yesterday we had a black male who made it to the jury. And then today was a Hispanic male. And he is a driver. He's married. And he did say something interesting from the article. He said something along the lines of, if George Floyd had complied, this whole thing wouldn't have happened. And so he made it on there. Let's take a look at him a little bit further. The newest juror, according to the Tribune, is a man who is married. He's Hispanic. He joins a multiracial woman, a black man, and 3 white men. And so this is why we got to talk about this stuff. 6th person chosen is a route driver for an unspecified business who acknowledged that missing work for a month would be a financial burden, but one he could endure, saying, if I am a good fit and can help, I'm okay. As for the case itself, the man said he's seen the viral arrest video in its entirety in the news reports. Obviously, he says, if Floyd would have complied, that wouldn't have happened. But he added, quote, there is more than that happened than just that. There was more that happened than just that. I am willing to see all the evidence and the witnesses. And so he made it onto the jury. Not a particularly, I would say, contentious interview with that juror. But we got over to the next juror who actually did get disqualified. And I want to just bring this up. We are going to talk about race here. This was an African-American woman who was rejected. And we're going to show you the back and forth that took place here because I think it was instructive. And you're seeing that a lot of these sort of juror battles are taking place over this sort of a racial issue, I think, but it's not. It's sort of being played out like it's a non-racial issue, like it's a legal issue. But they are coming up when we have people of color who are being questioned by the judge, by the prosecutor, and by the defense attorney. So back to the article, it says 2 rejected candidates were clear on their juror questionnaire responses and in comments in court that watching the viral bystander video left them troubled with how Chauvin treated Floyd. A woman who is black said more than once, you can't unsee it. She was pressed on whether she could put aside her opinion about what she saw and consider all the evidence in the case. The woman who is black responded, I will try my best, which is not a good answer, right? You can't try, you got to do it. The judge stepped in and asked whether it would be difficult for her to accept Chauvin's right to be presumed innocent before any evidence is presented, and she said, I do. With that, Cahill dismissed her over the prosecutor's objections and noted, quote, there are some legitimate concerns that you have that I want to honor. He said that to the juror. And so we're going to break this down. We're going to look at multiple different angles from this line of questioning because it was interesting. And it was something where I think the judge made the right move based on her answers. And the prosecutor, after they took a break, came back and objected just to make a record of this. You know, when you hear objections, many people think that, you know, they're about to go blows across the aisle and about to hit each other and slam each other into the desk. Not really, right? It's kind of just a formulaic thing that you do. And in this case, he was doing so to make sure that he made a record in case they wanted to appeal this and bring up questions to an appellate court about the disqualification of this juror. So kind of routine stuff. Now, yesterday we saw this article was posted over, this was actually this morning, says that a group of police reform advocates expressed concerns in the early days of jury selection in the Chauvin trial. A group of Minneapolis police reform advocates expressed concerns Wednesday about the makeup of the jury in the trial of former Minneapolis officer Derek Chauvin. 5 jurors had been seated by the end of the day, 3 white men, along with a woman of color and a black man, in a case that has sparked a national reckoning over racial bias in policing. 9 more jurors will be chosen before opening statements begin in the trial over George Floyd's death at the hands of the police. And this gentleman by the name of Nikema Levy Armstrong said, we need people of color on the jury. We need black elders on the jury, lawyer and activist said. She said, we need people who have a history of understanding the context for what is happening in this country. And I don't disagree with that, right? I mean, I think this would be something just from a political angle not even talking legally here, if you had a full white jury not convict Derek Chauvin, that's not good. Nobody's going to think that that was a legitimate trial. And a lot of what we're talking about and discussing around this case is legitimacy. And that's a reason why I'm so hell-bent on this show of trying not to politicize this trial, trying to just present the facts, argue both sides so that it is as unbiased as I can possibly make it. Now, I am a defense attorney. Okay, that's what I do. And so I'm going to, of course, lean one way or the other in these types of arguments. This case is a little bit unique because the defendant is a police officer who I traditionally go against, right? I typically am not defending police officers. They're typically on the government side. So it's kind of a new dynamic in a way. But my point here is that I think the best way to approach this is to look at the facts objectively and to try to analyze it from a blank slate. I know that's probably racist in and of itself, but my point is I'm just trying to present the facts, and I want to show you what's really going on here, because people from both sides are going to claim one way or the other that this whole thing was illegitimate and not a fair trial. I'm already seeing that from both sides. We have people who are saying that there's not enough black people on the jury. We have other people who say the media has already convicted Chauvin, and so we're seeing the lines drawn in the sand. I have not seen that right yet, okay? We've gone through this. We're on day 4. From what I have seen, this judge and both of these attorneys are running a very clean, as unbiased as I've seen a trial happen before. And so I want to show you this because we're going to start to see these allegations that we already saw it, in fact. The prosecution already came. They already initiated what's called a Batson challenge, saying that the defense was disqualifying jurors based on their racial demographic. By the 4th juror, the prosecution was already saying that. Okay, almost zero time to establish a pattern, and they were already saying that the defense was being racist. We talked about this a lot on Clubhouse last night. Very good conversation, very provocative, a little bit uncomfortable even because of what we're talking about. But this is important. This is the reality of conducting a jury trial. People on both sides are going to be looking at race. They're going to be looking at age. They're going to be looking at gender, whether somebody's got kids, where they grew up, how much money they make, what religion they are, and on and on and on. Race is just something that is obviously highly magnified in this trial because of the situation. Because we have a white police officer and a black decedent who are now we're trying to have a conversation about that. And so it is going to be a little bit of an uncomfortable conversation. That's okay. We love uncomfortable conversations because that means we're doing something. We're not actually just sort of sitting on our rears and feeling comfortable wrapped in bubble wrap so that we never get triggered. We want to have a real conversation, and so we're going to do that now. Next slide we have from, I think this is the original line of questioning that starts with this juror.
To clarify some things that you said regarding what you've seen, how what you've seen made you feel, and then what you would be asked to do.
Okay, so let me frame this out just a little bit better. I forgot what clip that was, but this is the prosecutor now who is questioning the juror, and so he picks this up after she's already been questioned by the defense attorney, and so she's made some pretty provocative statements like, "I can't unsee that video. I can't. I'm sorry, I can't unsee it." And the judge is trying to have conversations with her to rehabilitate her, to say, "Okay, I know you've seen it, but even though you've seen it, can't you just set that aside? Can't you be fair and impartial? Can't you give this a fair, fresh look?" And so she's kind of waffling on it at that point. Then the prosecutor comes back out, and he's doing a great job of rehabilitating her. He's really sort of leading her down this line of questioning that is just, yes, I can be impartial. Yes, I can set that aside. Yes, I know how important this is. Yes, I know this is justice, and we all want it to be fair. And he gets a series of yeses. Then the judge asks her some questions again, and then we'll pick it up. So let's get back to that clip. Here it is.
If you were a juror here, okay? And you said, I think, several times that you could set aside any strongly held opinions. Is that right?
Right.
Okay. And you could set aside any strongly held beliefs in deciding this case. Is that right?
Correct.
Now, if you were a juror in this case, the judge would give you instructions as to the law. And you would have to listen to those instructions and follow those instructions without regard to any beliefs or opinions that you had before coming in and hearing any evidence. Would you be able to do that?
Would I be able to follow instructions?
Yes.
Yes.
And if the judge gave you instructions, and if you followed those instructions, it meant that you had to return a verdict of not guilty. Would you?
All right, sorry. Let me
clarify some things that you said regarding what you've seen, how what you've seen made you feel, and then what you would be asked to do if you were a juror here. Okay. And you said, I think, several times that you could set aside any strongly held opinions. Is that right?
Right.
Okay. And you could set aside any strongly held beliefs in deciding this case. Is that right?
Correct.
Now, if you were a juror in this case, the judge would give you instructions as to the law. and you would have to listen to those instructions and follow those instructions without regard to any beliefs or opinions that you had before coming in and hearing any evidence. Would you be able to do that?
Would I be able to follow instructions?
Yes.
Yes.
And if those instructions, if the judge gave you instructions, and if you followed those instructions, it meant that you had to return a verdict of not guilty. Would you be able to follow those instructions and return a verdict of not guilty?
That decision is not solely made by me, correct?
That's correct. But if you, in looking at the instructions, I'm listening to the judge's instructions, I see what all of the elements are, I know what the evidence is, right? I've seen it, I've seen the video, I've seen everything, but if I listen to the judge's instructions and follow them, I would have to find the defendant not guilty. Would you be able to do that? Find the defendant not guilty if you believe that the instructions required you to do so?
If I was required to, yes.
Okay? And so it sounds like you formed, something, you had an emotional response to some things that you saw,
Correct.
but you would be able to keep that in context and understand that your job as a juror would be to look at the evidence as presented in court, listen to what the judge tells you, and follow exactly, no matter what the result. Is that right? Yes?
Correct.
And you're sure you can do that?
I will try my best.
Yeah. Well, and then, we have to make sure, because our job here is to try this case, and we have to do so fairly. And you would agree that every defendant, no matter what they're accused of doing, has a right to a fair trial. Do you agree with that proposition?
Yes.
And in order to get a fair trial, it's important that every juror can look us in the eye, raise their hand, and swear that they can be fair to every defendant, and to evaluate the evidence and follow the law. Not that they'll try, right? Not that they'll do their best, but they will do it. And so we're just asking you, do you believe in yourself that you could do that? You could follow the law, listen to the instructions, and decide this case on its merits no matter what way it cuts?
Yes.
Nothing further, Your Honor.
All right, so I know that's fast, but Miss Faith said that the sound sounds better. So the long and short of this is it's not as important about what they say, just as the process, I think, is what's relevant. The fact that he's just going again and again and again. Okay, set that aside. You sure you can do that? Yeah. And she goes, I'll try my best. And he says, okay, I know that you're going to try your best, but here's why it's important that we get a clear answer from you. Because this is a trial for what? And he goes through it and she says, yes, I can do that. Right. And she's not a resounding yes. It's like, an awkward pause there. And she goes, yes, is that the answer you want from me, man? I've already been talking for 10 minutes and yes. Oh, yes. Okay. All right. He goes, yes. Okay. Whew. All right. No further questions, Your Honor. And then it goes back over to the judge. And so this is where the judge then actually asks her, provides some space, opens the room a little bit. She's getting cross-examined by the prosecutor about being fair and impartial. And then this judge comes in and says, well, you can kind of be honest about this. I want to make sure it's okay. If you can't be fair and impartial, you just got to tell us. And of course, she does. So here that is.
I want to make sure you understand that sometimes jurors come in and they think that if they give a certain answer,
and I slow it down towards the end.
That's somehow a failure. It's not. If that's what it is, it's every case is different. It involves different issues, and we all bring our different backgrounds here. And I'm not questioning your answers. I'm just saying I want to give you the space to say, because you're not failing. If you were giving honest answers, that's all we require. There's no failure in saying fair and impartial. And if that's what you want to say, I absolutely accept it. Don't get me wrong. I just want to give you the space to be able to say one way or the other. Do you think that I'm going to focus on one issue, and that's the presumption of innocence? The defendant is presumed, as I told you yesterday, the defendant is presumed innocent of the charges made. And the fact that he's on trial cannot be held against him, or the fact that he's been charged. Do you think you could do that? Is presume that he is innocent as you enter the courtroom?
I wouldn't like that verdict, but...
Okay, so if it was not guilty, then right now you're supposed to, as opposed to at the end of the case, right now you're supposed to presume he is innocent. And you said something about you can't unsee that video, perfectly legitimate observation. Do you think with that it would be hard for you to presume the defendant innocent during the trial?
I do.
All right. Sidebar.
All right, so that was it. So the judge says, can you be fair and impartial on this? Can you find him, if you heard all the evidence, could you find Derek Chauvin not guilty? And she says, I wouldn't like that verdict. And he says, okay, but that's at the end of a trial. If he's acquitted, if it's a not guilty at the end of the trial, we know you wouldn't like that, but we're not at the end of the trial yet. We're at the beginning of the trial. Since we're at the beginning of the trial, can you understand the presumption of innocence? And she basically says, no, I can't. And then the judge says, all right, that's it. Right. That's enough. And so it goes on. They go on a break. The judge calls a sidebar and they have a conversation about it. And then the judge strikes the juror. They have a break. I think they go to lunch or something like that. They come back. And then the prosecutor comes back in and objects to that. So remember, this is an African-American woman who, they heard her say that she can't unsee that video. She's obviously very disturbed by the video, as most of the country was, still is. And they want her on that jury badly. Judge got her off the jury. So then they come back. The prosecutor raises an objection, says, I'm going to object to it, Judge. Here's my rationale for it. Again, this is to lay the framework for a potential appeal in the event they lose the trial. And the judge explains away again why he made the decision to strike that juror for cause. And remember, we have these two different strikes. You can strike somebody with a peremptory strike, meaning you sort of just get the ability to do that, don't have to give a good reason. And I learned today that surprisingly, the defense got 15 of those, 15 peremptories, and the prosecution got 9. And so I think the general rule in Minnesota is the defense gets 5 and the prosecution gets 3 in a case this long or this big. But the judge actually multiplied that by 3 on both sides. So the prosecution 3 turned into 9, the defense 5 turned into 15. And so they can exercise those at any time you want. The last clip that we have, where you're going to see the defense attorney uses a peremptory. But here the judge, just on their own volition, on the court's own motion, said, we're going to strike that juror for cause and get him out of there. So then the prosecutor comes back unhappy with it. And let's listen to what that exchange sounds like.
Thank you, Your Honor. The state opposed the motion to dismiss for cause for this juror. I don't believe she equivocated at all. I think that she stated very affirmatively and unequivocally that she could set aside her opinions, that she could set aside her beliefs, that she could apply the presumption of innocence. She stated it on a number of occasions, and she was questioned about it on a number of occasions, despite unequivocally stating so. What she said in terms of applying the presumption of innocence is that it was the difficult.
Did you just hear the same clip that I listened to? The judge just asked her, can you apply the presumption of innocence? She just said no. She just said, I don't think so, right? I can't do it. I don't have the transcript in front of me, but she just said no. So this prosecutor comes back and says she was unequivocal about it. She didn't even hesitate. You're going, come on, guys.
But that she could do it, and that she wouldn't like the verdict, but that she could render it. And when you have somebody who states as thoughtfully as she seems to have considered her answers under oath, that she would follow the instructions and decide the case based only on the facts that are presented and on the judge's instructions, then I think that is not a proper removal for cause. If the counsel would have wanted to use a preemptory challenge, he has plenty. He has 15 preempts that he could use. Those are extra preempts that have been given to him to account for some of the sensitivities in this case.
Well, let's be fair. Both sides have been given triple the normal.
That's true. We're entitled to 3. They're entitled to 5. You gave us 9. You gave him 15. So I'm not saying that's unfair. What I am saying, though, is that was not a proper cause strike. I believe that she very clearly stated her opinion, and she was questioned over and over. And I think that perhaps a little bit more than other jurors. And I would just state that I don't think that it should have been granted, and we object to it.
The court did excuse the juror for cause. To be honest, I was evaluating as we were going along, and I don't think it developed immediately. But she was very consistent in saying that she would put everything aside, but she couldn't unsee the video, which is, I think, that's another way of saying I couldn't put that aside what I had seen earlier. Granted, it's probably going to be in evidence, but it's that concern that she has about not being able to unsee the video. She had a very strong emotional reaction to it. She said she cried. They had a very negative opinion of Mr. Chauvin, all of which does not constitute cause. But the bottom line being, it seemed to me that she was walking into the courtroom, especially when she said, I could render that verdict, but I wouldn't like it, is that she was not in the middle neutral, but actually, which is why the court asked the presumption of innocence question. And when I finally gave her the space to say, how do you feel? Do you think sitting here right now, and it has to be right now, not later, can you presume the defendant innocent? She answered unequivocally no. That's the primary reason why I granted the cause challenge. I think there was sufficient, I agree with you, there were sufficient other things if the defense had wished to use a peremptory strike. She also had issues with child care as a single mom without a lot of strong support, but that was not the basis for the court's challenge because she did say she could be able to work through those. So with that, we'll go to the next juror.
All right, and I think that's exactly right. It's exactly fair. So I understand why the prosecution had to make that opinion, make that statement, but the judge, she said unequivocally, no, I can't follow the presumption of innocence. And that's exactly what this whole process is for. But there will, of course, always be people claiming that that was because she was an African-American woman and not about what she said. You can come to your own conclusion on that one. So we've got 6 jurors now seated. We've got some more to go through. I just don't know what my clicker did. All right. So here is what the jury panel looks like. This is where we're at. So tomorrow we'll see how far along we get. Maybe we get 7, 8, maybe 9. So that would be on a Friday. If we can get 3 tomorrow, start back up on Monday, get another 3, maybe finish by Tuesday. Maybe. Now, if we just have 1 a day, we can see this could take a while. We could have, Friday, Monday, Tuesday, Wednesday, Thursday, Friday, Monday, Tuesday, for example. So it could go over another week. So we'll see. We'll see if they pick up the pace tomorrow. I know that there are some additional motions that they're arguing about. At the conclusion of one of the segments today, they were talking about they've got all of these thumb drives and a lot of data that they're going to give to the judge, I think tomorrow, so that he can review it over the weekend. And it was actually pretty funny. Eric Nelson, the defense attorney, said that typically the defense attorneys have better sense of humor, by the way. And so he said something like, well, Your Honor, we're going to deliver all of these thumb drives to you, and then you can review them over the weekend. He said, we'll grant you enough time to review them over the weekend, and then we can have your answer on Monday. So they submitted some additional thumb drives, and the judge laughed at that, right? It was kind of fun. So the judge will be able to review everything. Then they're going to come back on Monday and talk about motions in limine and specifically about what can come into court, what different evidence, what different rules do they need to follow about testimony and things like that. So we still got a ways to go. Near the end of the juror selection today, there was a very interesting conversation with a prospective juror who, I don't want to say was dishonest, but he was less than truthful, or he was just absent-minded. Could be one of those things. He could have just forgotten about this. But remember, they all submitted questionnaires, and as part of the questionnaires, they were asked things like, do you support BLM? Did you go march? Did you go down and visit the scene? Those types of questions. Did you post anything on social media? Did you talk to your family? Did you, go on Facebook and communicate your opinions on any of these things? And the juror here sort of gets into that line of questioning, but then we see that Eric Nelson and his defense team, they checked his social media. And in fact, there's something there. Let's listen in and see what this is all about.
We were talking about some of the opinions and things that you held, and I have a question for you. It asks, did you or someone close to you participate in any of the demonstrations or marches against police brutality that took place in Minneapolis after George Floyd's death? And you checked yes, and then there's not any information. Did you personally participate?
I did not.
Okay. But you did visit the site of 38th in Chicago?
I did.
Okay. And in fact, you posted about that on social media, correct?
I don't recall. I probably did.
Okay. Would it surprise you to learn that we're looking into the background of our potential jurors, and that I looked at your social media?
Okay.
You wrote that you went to the site of the George Floyd Memorial at 38th in Chicago where he was murdered. There was a mix of all sorts of people. They were for people providing food and supplies for those in need, people crying, people sharing, hugging, laughing with each other. Holy ground. There was a time for prayer that lasted 9 minutes. Most knelt for that. 9 minutes is a long time. There is a groundswell for change. It was peaceful and beautiful and moving. Right?
I'm glad I wrote that.
Okay. And again, you are entitled to your opinions, right?
Yeah.
And some opinions, right, they're a little more flexible than others, right? Would you agree with that general concept?
Sure.
And other opinions are very, very, very entrenched in our lives, right?
Yes.
Right? And those opinions can affect our decisions. Would you agree with that?
Yes.
Okay. So whether you have a opinion, you would expect your opinions to sometimes guide your actions, would you not?
Right.
If you hold a particular religious belief, or you hold a particular philosophical belief, or even if it's simply my favorite music is X, right?
Right.
You turn on the radio and you listen to the music, your opinions guide what you do. You agree with that?
Sure. Yep.
But this is a case of tremendous importance. You said that.
Yep.
And my concern is that you're telling us that you can set aside your opinions, and you can judge this case only on the evidence presented in court.
Yeah. I mean, I think it's a matter of recognizing the situation that I'm in as a potential juror and the responsibility to, like I said, clean the slate and start fresh from what's presented in here.
Okay. If you felt, after all of the evidence was presented in this case, that the state had failed to meet its burden of proof beyond a reasonable doubt, would you have any hesitation in finding Mr. Chauvin not guilty?
I don't think so.
Okay. Again, it needs to be unequivocal, excuse me. Could you?
Yeah, I can imagine that, yes.
Would you then post about that on social media?
I don't know. I kind of decided that I'm refraining from any of that kind of posting right now. I'm posting music that I like and that kind of thing.
Right. But I mean, you posted and you have an opinion that 38th in Chicago is sacred ground or holy ground. I don't remember what you used. Right. Would you be able to proudly say to your friends and Facebook followers and family members, I was a juror who found Mr. Chauvin not guilty? Objection.
Objection overruled.
I guess I can imagine that possibility. That's probably as most best I can answer that.
Okay, fair enough. Your Honor, we'll exercise a peremptory.
Thank you, sir. You're excused from this jury. That'll also complete your jury service for this term, so you don't have to report back to anybody. But you can gather your things. The deputy will take some paperwork from you, and then we'll just wish you a good day.
All right, so that juror got struck. It was a peremptory, which means the defense just got to pick it and said, nope, he can't be on the jury, and for good reason, right? That juror didn't disclose or didn't remember or whatever that he was down there at the site of the killing, of the death of George Floyd, and he was posting on social media calling it sacred, hallowed ground, and that this was something that there's a groundswell of support and on and on and on. And so that was obviously a very passionate statement. And many people feel that way, and there's nothing wrong with feeling that way at all. It's not a commentary on that statement. But what the defense attorney then did is sort of spun that around and said, okay, well, you posted that on social media. If you sat here in this courtroom and all the evidence was presented and the government didn't meet their burden, would you be okay going back on social media and posting, yeah, I was on the jury and I sat through the trial and Derek Chauvin's not guilty? And you could hear him in his voice go, So his answers were right. He said, yes, I can be fair and impartial. The prosecution would be able to get him back up there and say, yeah, I'm fair and impartial. Yeah, I can set all that aside. Yes, it's a blank slate, blah, blah, blah. But the defense attorney just knew, no. I mean, right, it's so entrenched. If you make a statement like that one way or the other, it's very unlikely that you are going to be on a jury because of that, the heft of that statement. And it would go the other way as well. If some juror was on there and said, I posted that Derek Chauvin's an American hero. He's out there fighting crime, and he's just trying to save our society from the dregs or whatever, right? Some statement like that was very provocative. Then he also would not be on the jury, and the prosecution would have used a peremptory to get them off of the panel. So it is interesting, how people forget. And obviously, remember, this happened a long time ago. These questionnaires probably happened a long time ago. So I don't want to presume that, a juror is being dishonest or anything like that. But, you would think that if you literally went down there and you were sort of involved in it, that you would disclose more of that than apparently he did. And Eric Nelson, the defense attorney, his team scoured the social media and found that post, and that juror shouldn't have been on there, right? I in my opinion, I don't think that they are fair and impartial. If you're out there, you want to find other people who have, I think it's going to be very difficult to find anybody who knows nothing about the case. This is a national story. It's been at the top of the headlines for months. And so the idea that you'll get a total blank slate, I think is unreasonable. But you still want people who are closer to the center than somebody who posted a statement like that. So he is not going to be on the jury, and he shouldn't be. Neither should other people on the other side. This is what the process is all about. All right, let's jump into some questions over from watchingthewatchers.locals.com. If you want to ask a question, head on over there. First one here is from It's Ed. Said, not trying to take a side here, but how does someone stand a chance in court when the government has deep pockets to bring heavy hitters in to prosecute you? This seems like Chauvin doesn't stand much of a chance. Well, It's Ed. This is just how it goes. This is how it goes for every single defense attorney in every single trial that's ever happened ever, really, as far as I know. The defense teams, the defense attorneys are typically, it's a David versus Goliath situation. I mean, the government has billion-dollar police agencies here in Arizona. I think our budget for our Phoenix PD is $1 billion. Now you combine that with Scottsdale and Mesa and all of the other law enforcement agencies. It's a multi-billion-dollar industry here. They've got thousands of employees, hundreds of prosecutors, expert witnesses on staff. I mean, they have the whole thing. So any defense attorney who's defending anybody, anywhere, is facing long odds. Not to mention that the entire system is politicized. Jurors just totally forget about the presumption of innocence. They just presume your client's guilty. Even if the judge tells them you can't think that way, they still do because of what they just think in the world. I mean, it is a challenge. There's no question about it. Now, Chauvin is at a special disadvantage because of the eyeballs on this case. It's so magnified that the government is really reaching out and bringing in heavy hitters across the board. I mean, they're pulling out all the stops to make sure that they can get a conviction on this case. So is it unfair? Yeah, probably. Is it unusual? No. I don't think so. It's just kind of how the game goes. Defense attorneys are, in my opinion, always the underdog because you're going up against a massive bureaucracy, and not to mention just the conditioning that society has as it comes to cops. That you see this all the time. He wouldn't be here if he didn't do something. He wouldn't be in handcuffs if he didn't do something. Well, we're all starting at a disadvantage, which is why I'm so passionate about what we do, because I like representing the little guys. All right, so here is another one from JBone86. Says, should the defense consider muddying the waters with Antifa Keith's documented anti-white, anti-cop prejudice? Antifa Keith? No, I don't know anything about that. Antifa Keith, is he the attorney general there? So he's got anti-white, anti-cop prejudice? Well, I don't think so. If I'm Derek Chauvin and I'm his defense attorney, I don't want to make this about race at all, not even a little bit. That's the last thing we want to talk about. This is just law enforcement procedure. You can disagree with the procedure if you want, but it's not about race. And I think Eric Nelson is actually taking that tact, right? He's when the prosecutor came back out and wanted to hit him over the head with that Batson challenge, he said, no, it's not. He was able to articulate, I think, 5 reasons for why he wanted to strike that juror. So I know that the inclination here is to sort of jump into the racial and the racial conversation and duke it out over that. It's obviously relevant. It's obviously going to play a huge role in this trial, but from a defense perspective, if you're defending Derek Chauvin, I don't think it serves your side to bring that into the fray. Now, if you're the prosecution, yeah, it certainly serves you to do that because that's sort of the political momentum behind the case is supporting that theme. And so that's the theme that they're going to run with. Right, we have this over from Jeremy Matrita says, purely speculating here, any chance a judge will behave a certain way or make certain decisions based on political intentions of getting promoted to a higher court. Not saying this judge is doing this per se. Yeah, it's a great question, Jeremy. And I think that absolutely that comes into play, right? Every single person. Now, this judge, I think he's been on the bench or he's been a lawyer since 1984. I remember saying he's been practicing law longer than I've been alive. So this may be his sort of end game. I don't know this in this judge in particular. But it feels to me like it is. Like he's got no real ambitions to go up to the appeals court or whatever that is. And he's kind of happy there. I haven't seen him acting one way or another to, I would say, appeal to somebody else who's not there. I think he's running his courtroom very fairly. Now, I know you asked about broader implications here. And I think that, yeah, anytime that you're talking about any human being, they're always thinking about what their next move is. Judges are no different. Now, judges are a little bit different because many of them have sort of lifetime tenure in different jurisdictions, and some of them are sort of in the limelight of their careers. So they've already been a prosecutor, they've already been a private attorney. Now they are judges, and so they're not really looking to go run for office. This is kind of their final stop before they retire off into the sunset. And so it's just like anything, though. You'll find younger judges who seem to be like, they're trying to prove something to somebody. They want to go out there and make a statement about something. But I don't get that sense in this case, but it's a good question. We have another one from News Now Wyoming says, after doing a write-up on the charges today and an examination of what has been publicly released, I am no longer sold on second degree. Reaching that intended to cause felony assault is hard for me to agree with. Third degree, I am more hopeful for. Any predictions or too early? Yeah, I think it's too early. There was some rumblings around on the first day that the defense attorneys were going to be bringing out some or attempting to get in a 2019 arrest from George Floyd, where they're saying the allegation was that he ingested drugs at the last minute, and they're going to intend to show that he did that again in this case, which was sort of provocative, something that I hadn't heard before in formal court documents. A lot of rumors running around, that he was doing whatever. That's all fine. Rumors are rumors, but what comes into court? And the defense attorney, Eric Nelson, actually brought that up. He said, yeah, we're sort of intending to show that this is George Floyd's modus operandi. Anytime he has any interaction with law enforcement, first thing he does is he just downs whatever drugs are on his body. If that is evidence that is submitted in court, I don't know what the jury's going to do with that, but I think that is not good for the prosecution. So back to your question, though, intended to cause a felony assault. I can see why you think that's a hard case to prove, because especially if the defense team can show that the knee on the neck was part of policy. And as we know, the policies were modified after George Floyd's death multiple times, multiple revisions that basically said that is no longer an acceptable policy. But if he was operating within the policy, if he was operating within the use of force guidelines, how can that be a felony if it's official police protocol? I think that's what their argument is going to be. I think it's too early for me to predict anything right now. I will tell you this, it does feel very lopsided in terms of the attorneys. The government has some seriously heavy hitters, and that doesn't necessarily mean much of anything. A lot of it's going to depend on the jury. Today was a loss for Derek Chauvin for sure. He has another charge now that he has to defend against. That's just one more option for the jury to consider, right? Rather than having to decide on two, they can maybe split it. They could say, all right, well, we're not going to get him on the second degree or the third degree, but we'll get him on the manslaughter charge, just because we got to convict him on something. So they'll find something to convict him on. And so if you have three, I think it's easier to slide in that last one, acquit on the two, maybe convict on the third. I don't know. It's going to be interesting. I'm curious to see what evidence ultimately comes out. We've got Tremendous says hello to both of you. And Ma, Dave Rubin came up with what I feel is a bizarre story. He feels that the prosecution wants the third-degree murder charge so that if Chauvin is convicted of the other two charges, but not the third-degree murder charge, there will still be rioting because he wasn't convicted of all three. Do you have any thoughts on other more reasonable reasons the prosecution wants to add the third-degree murder charge? So is Dave Rubin implying that the prosecution wants riots? He says the prosecution wants the third-degree murder charge so that if Chauvin is convicted of the other two, but not the third, there will still be rioting. So meaning they want to add the charge. They don't think that they can get a conviction on it because they want riots. Do you have any other thoughts, more reasonable reasons why they want to add the third-degree murder charge? Yeah, I mean, I think they want a conviction, truthfully. I think that, as we went through the defenses, I think there are actually good arguments for them, especially if the toxicology report gets admitted and explained away as a very recent sudden ingestion of drugs. So I think that, I think if you're a prosecutor, it's like more at bats, right? You want to get up to the bench multiple times. You want to get up to the plate, try again, try on one, try on two, try on three. It's one more try than just the other two. It's one more charge that they can secure a conviction on. So if the jury doesn't want to, convict on the most serious charge, maybe they don't want to convict on the least serious charge, they go right in the middle with the third-degree murder charge. So I think that's ultimately what it's about. I can't imagine that the prosecution would want to support riots in the street or anything like that. So I'm not sure that David Rubin is making that allegation or what his position is on it, but yeah, I think the real reason is they want convictions. 3 attempts are better than 2 attempts, long and short of it. We have Norovira. Rob says, Rob, I disagree with the demand of more color on the jury. They have absolutely no right to ask for that. If the jury summons was sent out randomly and people who responded have responded, that's the fair way of doing the process. This jury of his peers, 1, jury of his peers, 2, jury able to weigh the evidence and presume innocence. This is why the prosecution has 9 strikes. Go and use them. Yeah, I don't have any, I don't have any disagreements with that. Actually, I think that the long and short of it is there should be a non-racial, non-biased, neutral process for sending out notices of jury summons, collecting people that come in, asking them to fill out questionnaires, putting them through a neutral line of questioning, and seeing what comes out the other end. And quite frankly, that's exactly what's been happening here, as far as I can tell. Now, the prosecution, of course, they're going to say that this is a racial thing. That's part of the theme. I'm not even mad about them for doing that. That's not even a problem, right? That's exactly what they should be doing. That's the theme of their case. And many people don't understand this. They think that, well, they're just being racist or whatever. And both sides have to develop a theme. And this is the beauty of the adversarial system. Both sides should get fair, equal resources. Never happens. The defense is always at a disadvantage, but that's okay. And what happens is they both present their arguments as aggressively as possible. The government is going to create a theme. What is the theme? Well, this is a white cop killing a black guy. There was some malice there. There was some sort of intention to do this. Justifies a murder charge. And so they have to create, if they want to prove their case, they got to come up with a reason why. What's the motive? Why did he do this? And so race, of course, is at the top of that list. So they have to cultivate that in order to move it forward. That's just part of the process. You can disagree with it. You can think that it is not appropriate. You can think that there is no racism or whatever, but that's the theme. That's the theory of the case. So they should do that. The defense, by contrast, is going to do the exact opposite of that, right? If the prosecutor wants a bunch of BLM people on the jury, the defense wants a bunch of cops on there. Fill it with former officers. If they could do that, they would do that. Same with the prosecution. And you can't blame them for that. It's just the nature of the system that we have, which is a good system. It's adversarial. Both sides get to come at each other, duke it out, and the better decision is made as a consequence of that battle. But I know it's provocative. I know saying that stuff is not politically correct, and it is a little bit touchy. It feels a little bit off, but it's just how it works. That's what we're talking about. We got Sharon Quidney says, wait just a minute here. How can this be anything but politicized? You are right that you should have a balanced jury in order to be legitimate, but where are you going to find people of color who are not already biased against anybody who is white? This just points out the contentious nature of everything. Well, yeah, I mean, I don't want to generalize for people of color not disliking or not being biased against white people. I think that we all have our biases, right, about certain things in life, and I think is that what they're teaching now? Is that right? I don't even know what people are teaching or what the biases are. What are you allowed to say? Are we all biased? Are we all not biased? Are we all racist? Not racist? I can't even tell anymore. It's too hard to keep track. But the point is we also have to talk about legitimacy on a political level. And I'm not an African American person, but I would imagine that if I were, and Derek Chauvin is acquitted by a jury of 12 white guys, that's not going to feel like a legitimate trial to me. just speculating, right? And it would be the converse also. If this were, if the country were flipped and, the white people were the minority and a black cop killed a white guy and there was a trial over that, and the jury was filled with a bunch of black guys, and they all convicted or acquitted the the black cop who killed the white guy, right? Everybody would be going, this feels interesting. This feels a little bit strange. And so I know that that's the first instinct to jump through, and I know that people are going to make those claims regardless of the outcome. We're going to hear that until the end of the world. My only point is what we're discussing here, what we've seen in court thus far, is pretty dang good. There's not a lot of this racial stuff coming in. The judge accepted the Batson challenge from the prosecutor, who said this is racist. He heard it. We all know they have to make that claim, but the judge said, no, I'm not seeing it. I'm not seeing it. He had justifiable reasons for the peremptory challenge. And I also had some concerns myself, by the way, and we're moving forward full steam ahead. So I think that it is mostly good right now. We'll see if that changes direction anytime soon. Liberty or Death says, how long do you think it will take the state to turn its racism accusation and Batson challenges on the judge? Good question on that. That's a good question, Liberty. I don't know. I think we might be getting closer to that, actually, because on Tuesday when we started jury selection, we saw the first Batson challenge after the fourth juror, I think, was called up. Not the fourth seated juror, the fourth juror who was even to be questioned. So it didn't take long for that to come out. Then today we have an objection, right? We saw an objection. And so that's kind of the progression, right? You have a Batson challenge, I would say. Then you have an objection. Well, Judge, you dismissed her for cause, and I don't think that's lodge my objection. Maybe as we move up the ladder, at some point they say, well, Judge, I don't think that's going to happen, honestly. I don't think this judge has hinted at all. If it does happen, I think that would be totally inappropriate, because what I've seen thus far, he's very reasonable. And the defense really hasn't, as far as I've seen, done anything that we would even resemble racial undertones for their peremptory or disqualifications. So we'll see. It's a good point. Wouldn't surprise me if it happened. I hope it doesn't, though. Remark number 2 says, can they appeal on the basis that the judge couldn't be understood with the mask on? This is actually a good question, and I think this is a very important question that I think is ridiculous. So Arizona is not really doing jury trials right now. We just haven't done them. And many attorneys are now saying that they're just refusing to do them. They're not going to do them, largely because you can't see anything that's going on. If you've got plexiglass all over the place, if you've got something covering your mouth, jury box can't hear you, witnesses can't hear you, even the micro expressions that you get from watching people. Right, you can kind of tell when somebody's off a little bit. Their face moves a little bit. They sort of look uncomfortable in their cheeks and in their eyes. And if you have a mask that's covering up, 2/3 of your face, you can't see that stuff anymore. And that's critical. You can't see what the jury's thinking. When you're out there giving your closing arguments or your opening arguments or drawing a line of questioning, you're sort of watching off on the jurors to see whether somebody's wincing or looking away or asleep. And you want to go over and talk to that juror and you sort of, get in their space and bring them back into the show so that they are aware of what's going on. And a lot of that stuff becomes difficult to do if you are socially distanced, if they're all segregated apart and you can't see anybody, if everybody's wearing masks and there's plexiglass all over the place. So I think that there actually may be some procedural issues that come out of all of this. I don't think so in this case. I think that the judge is sort of bending over backward to make sure that everything can be seen and heard. They actually pretty well teched up. You could see somebody in there with a switcher. So I don't know. I think we have a difficult time hearing the judge, but presumably they can all communicate with each other. And so an appeal on that basis, I think, wouldn't go anywhere, but it is a good issue. Last question over from locals.com says, NY Renal MD, the doctor's in the house, says, it's a big inconvenience when I have jury duty. Not a lot of flexibility in my schedule. Do defense attorneys and prosecutors like or dislike potential juror like myself with a professional background, especially if I may have expert knowledge in the area that the case involves? So generally speaking, I think that the answer there is dislike. Generally speaking, it sort of depends on the profession and the subject matter, and it depends what your arguments are. But generally speaking, people with really professional backgrounds, and especially people who have an expert knowledge in the area of the case, they tend not to make it onto juries. And the reason being, we sort of saw this yesterday. There was a civil lawyer who was called in for jury duty. She made it onto the panel. And she got questioned and they disqualified her. She's a civil lawyer, doesn't know much about criminal law, but the problem here is that if she is brought into court or if she's brought into the panel, then the rest of the panel members may just look to her and say, well, you're a lawyer. Tell us what to do. All right, tell us what you think about this. Yes or no, explain this to us or explain that to us. And so the lawyer sort of becomes the de facto chairperson, whether they want to or not, just based on their experience. And same for you, Doc. You know, if you're a doctor, you've got professional experience, you can come in and opine about a lot of other things that a layperson may not be able to discuss. And so just because of the fact that you're sort of elevated, you've got a prestigious background, you're a doctor, you know, you're somebody who saves lives. Well, you are bestowed a special sort of reverence from other people, just naturally speaking. And when you're in a confined area with a limited amount of jurors talking about very, very, controversial, difficult concepts, you may see that people just generally, naturally gravitate to you. And you don't want that on a jury. You don't want any one person, unless that person's going to find in your favor, then you certainly want them on the jury so that they can pull people over to your side. But it's a case-by-case basis. But I would say, generally speaking, you're looking at those people with a little bit of caution just because of that sort of gravity effect that they have on other jurors in the panel. Good question. Thank you for all of those that came over from locals.com. We have a Watching the Watchers community over there. So if you want to join up, download these slides, get to know people, you can do it over on locals.com. All right. So that's it for Derek Chauvin. A couple short segments we're going to go through here. Just a little touch on these stories here a little bit. Andrew Cuomo back in the news. He is now facing an accusation from a sixth accuser about groping. And this groping charge may actually turn into criminal charges. This is being referred over to the Albany Police Department. This comes over from the nypost.com, doing good reporting on this topic. It says the Albany Police Department has been formally notified about the allegation that Governor Andrew Cuomo groped a female staffer in an incident that may amount to a crime, a source familiar with the matter said today. Cops have not launched an official probe, but, quote, have reached out to the victim's attorney and offered up any other police assistance, a police spokesman said. At this time, there's been no formal criminal complaint. There is no active criminal investigation, they said. And so my first question here, which I didn't see in the article, is how long ago this occurred. Maybe it is in the article. Before I opine, let's finish the article. It says here, Cuomo's acting counsel, Beth Garvey, acknowledged in a statement that state officials had referred the matter for possible criminal investigation. As a matter of state policy, when allegations of physical contact are made, the agency informs the complainant that they should contact their local police department. If they decline, the agency has an obligation to reach out themselves, inform the department of the allegation. In the case that the person is represented by counsel, and when counsel confirmed the client did not want to make a report, the state notified the police department and gave them the attorney's information. In a statement, New York State Police also said it reached out to the Albany Police yesterday to facilitate a contact with the executive chamber regarding the alleged incident. And so my first thought on this was about the length of time that takes place here. Anytime you have one of these sexual assault allegations or, one of these groping types of cases, one of the first questions that I have is how long ago did this happen, right? And why did this take so long to report? Why wasn't this immediately reported to the authorities? Is this a buyer's remorse thing? Is this a dogpile thing? Is this a vendetta? Is somebody being vindictive? There are a lot of reasons why people manufacture claims later on down the line, and especially when it involves high-profile, high-power individuals. We've seen this story many times before. The floodgates open, accuser after accuser after accuser. Okay, so there are some rules around this. And one of the key concepts here is what's called the statute of limitations, which means you got to bring your case soon. You can't just file it 25 years later because evidence dissipates and the ability to bring remedy, the ability to redress your complaint sort of disappears the longer the time goes on. And so in Arizona, for example, let's say that you are charged with a misdemeanor for criminal trespass or something like that, and you are arrested for it, but they decide not to prosecute you or press charges. And so the charges are sort of floating around a little bit, and a year goes by. They can no longer bring those charges against you anymore. They're gone. They lost the opportunity to do that because they waited a year. Our statute of limitations for misdemeanor crimes is 1 year. Bring the charges within 1 year. If you're in an altercation with your spouse, let's say I'm dating a woman, she punches me in the nose, I get over it that night, I wake up 6 months later and I want to file a report, I can do that. But if I wake up 1 year and 1 day later, I can't do that. The statute of limitations has expired. Now, for felonies, it's 7 years, which is a much, much longer term, and this can be very problematic. For sexual assault cases, virtually no statute of limitations on that at all. And so it depends on how they're going to charge this. Is this an assault where he is groping somebody? If so, is it a short statute of limitations? And does that expire? Or did this expire because she didn't bring the claim soon enough? Or are they going to charge this as a sexual assault type of a crime that basically has no statute of limitations? And again, I don't live or work or practice law in New York, but I'm going to guess it's largely the same framework for these types of cases. So that's my first question. Why now? Why is this coming up now? How long ago did you bring this charge? Let's go back to the article from the Post. It's unclear at this point whether the accusation against Cuomo is something that rises to the level of a crime or assault, a source familiar with the matter said. Albany County District's attorney declined to comment. So that's the prosecutor's office. But a source there said Cuomo couldn't be prosecuted unless the accuser cooperates with the authorities. Reports have come from a direct victim. They have to come from a direct victim and be filed with a law enforcement agency, whether that be the DA's office or the police agency. So Garvey, Cuomo's lawyer, held a conference call Thursday with members of the staff, Cuomo staff, during which she gave them multiple options for reporting complaints about harassment, a source who listened in told the Post. So she's telling people, yeah, if you got a problem, go file it. Garvey said a worker could talk to her, a supervisor, or a private lawyer. The incident was referred to the police, allegedly took place late last year in the executive mansion in Albany, and the Albany Times reported on Wednesday. So it looks like it would be within the year. So even if it is an assault charge, they could even bring that, probably. Again, I don't know what the statute of limitations there is in New York. A person familiar with the woman's account told the paper that she said Cuomo put her hands under her blouse and groped her. So that would probably elevate it to a higher level sex crime. Right? Typically when the nipple's involved, that's off limits. No good. The female staffer who hasn't been identified beyond being a much younger person than Cuomo was reportedly summoned to the 60-year-old governor's official residence to fix a problem with his cell phone. Oh, don't you hate that? Don't you hate when you have a problem with your cell phone and you got to call some underage staffer into your residence to come help you with that? Man, it's a huge problem. Poor Cuomo. The conduct, here he is. That conduct, called forcible touching, is a misdemeanor with a maximum sentence of 1 year in jail. The groping allegation is the most serious to emerge in the wave of accusations that followed last month's publication of an online essay in which former Cuomo aide Lindsey Boylan detailed what she described as a pattern of sexual harassment by Cuomo, including kissing her on the lips in the office in 2018. So see, that's old, right? So if that would be assault, that's probably too old to charge. Cuomo's office has never made any comments since the governor, who has repeatedly said, quote, never touched anyone inappropriately, issued a statement on Wednesday night denying the allegations in the Times Union report. As I said yesterday, I have never done anything like this. The details of this report are gut-wrenching, Cuomo said. I am not going to speak to the specifics of this or any other allegation given the ongoing review. That's good legal advice, but I am confident in the result of the Attorney General's report. He pledged to cooperate with the probe and urged New Yorkers to withhold their judgment pending its findings. So we'll see if New Yorkers end up doing that. I'm going to guess that they do, actually. I think that most people there still think that he is the savior, the COVID savior. So we'll see what happens. But a lot of individuals who are part of the government are saying he's got to resign. 55 New York Democrats call on him to resign for the scandals. More than 55 state legislators called for Cuomo to resign. Assembly Speaker said that he would hold a meeting on the event later in the day on, quote, on potential paths forward. The statement from Cuomo's fellow Democrats cited both the spiraling sexual assault harassment allegations against him and the cover-up of the nursing home death toll, and said that he has lost confidence of the public and the state legislature. They say, we have a lieutenant governor who can step in and lead for the remainder of the term, and this is what's best for New Yorkers at this critical time. It is time for Governor Cuomo to resign. Speaker Assembly Carl Hesty said, quote, in light of the allegations concerning the governor over the last several weeks, I will be meeting with members in conference today on the potential paths forward. Cuomo has faced mounting calls to resign or face impeachment as the twin scandals have intensified amid a seemingly endless parade of new revelations and allegations. And I'd be curious what other New Yorkers there think about it. We're going to hear from Blasio here in a minute, but let's finish this article. It says, under the New York Constitution, impeaching Cuomo would require a simple majority vote of the 150-member state assembly, which is composed of 106 Democrats, 43 Republicans, and 1 independent. And so currently we have, it looks like 55 total. I'm wondering how many of those are Republicans, probably almost all of them. Let's take a look. What did that say? 55 Democrats. Okay, so think about that. So those numbers are pretty high then. So if we got 55 Democrats plus, let's say, 43 Republicans, if they all vote to impeach, that's the majority, isn't it? Yeah, that would be the majority. A resolution to impeach Cuomo was introduced earlier this week by Republican members, with Minority Leader Will Barclay saying, quote, "We believe the time has come to oust the 3-term governor." Whoa, so this is actually heating up. I didn't think anything was going to happen to Cuomo, but looks like there's enough momentum there to do it, including from Mayor de Blasio, which also nobody likes anyways. So New York is just sort of purging itself, it sounds like. Here is de Blasio.
The latest report and the fact that we can talk about how many people are bringing forward accusations, that it's not 1, it's not 2, it's not 3, it's not 4, it's not 5, it's 6 women who have come forward. It's deeply troubling, the specific allegation that the governor called an employee of his, someone who he had power over, called them to a private place, and then sexually assaulted her, is absolutely unacceptable. It is disgusting to me. And he can no longer serve as governor. It's as simple as that.
All right, so we'll see what happens with him. We'll see if there's criminal charges surrounding that. Certainly would want to know what her side of the story is, what the police report shows, what the details are surrounding that. But he's still in hot water, and he's going to be for a long time. So that's it for Andrew Cuomo. All right, in our last segment of the day, short segment, we learned that a Florida woman was originally charged, not a Florida man, a Florida woman, was originally charged with murder and dismemberment of her daughter-in-law. Sounds like a Florida case, kind of, doesn't it? Well, fortunately for her, cell phone evidence got her off the hook. This article comes over from lawandcrime.com. Charges were dropped against this woman. Her name is Wanda Rivera. She's 61 years old. She was accused of helping cover up the murder and dismemberment of her daughter-in-law. New evidence cast reasonable doubt on whether she helped move a car of the victim, who was named Nicole Montalvo, 33 years old, according to a filing from prosecutors. And we have that document we're going to go over today. The state maintains that cell phone analysis supports the finding that Montalvo's estranged husband, Christopher Otero Rivera, 33, and his father, Angel, removed the vehicle from their property on the morning of October 22nd, 2019. While this new evidence is not conclusive as to the nature and the timing of the vehicle's removal, it creates a reasonable doubt as to Wanda Rivera's guilt and ethically obligates dismissal in the interest of justice, the prosecutors wrote today. The Riveras are Otero Rivera's parents. Prosecutors originally argued that Wanda helped her remove the vehicle. The men facing charges, including murdering Montalvo, was last seen dropping her 8-year-old son off with her father and grandparents, which is just terrible. In search for the missing woman, it started when she did not pick up her child from school, ended when the deputies found her dismembered remains on the Rivera property in St. Cloud, Florida. Otero Rivera had a history of allegedly committing domestic violence against Montalvo. This included allegedly kidnapping and beating her in a 2018 incident, then trying to get another man to discredit her as a witness. Angel allegedly told prosecutors he saw his son with her body and that Otero Rivera admitted cutting her up with a big blade, according to the redacted documents obtained by the news. They both pled not guilty, and that trial is scheduled for April 5th, which is just a gruesome story. Here is the article. Here's the document. It says that this was filed in the Circuit Court for the 9th Judicial Circuit, State of Florida, in and for Osceola County. 9th Judicial Circuit, State of Florida versus Christopher Otero. So they must have a 9th Circuit there in Florida. Did not know that. All right. So here's what they're calling it. A nolle prosequi, which is not something we use here in Arizona. It's basically a motion to dismiss. It says comes now. State of Florida, by and through its undersigned, enters its announcement of a dismissal against the defendant, Wanda Rivera. The state has received new evidence that creates reasonable doubt as to the charges alleged in the second amended information, which would be the complaint. This evidence consists of cell phone analysis supporting the conclusion that co-defendants, Christopher and Angel, removed the victim, Nicole, their vehicle from their property on the morning of Tuesday. This new evidence is inconsistent with the evidence upon which the charges were filed that supported the state's original belief that Wanda Rivera assisted them in removing the vehicle on the evening of Monday. While this new evidence is not conclusive as to the nature and timing of the vehicle's removal, it does create reasonable doubt as to Wanda Rivera's guilt and ethically obligates the dismissal in the interest of justice. This action acts to dismiss the charges constituting any and all charges from the underlying complaint, certified and signed off on the 5th day of March. So interesting case that I had not heard of before, but it is I'm always curious when technology is being used as a defense or is being used as a way to present evidence, really. And so it sounds like here, this woman must have had a cell phone that she was using, that somebody could corroborate the other end of her communications, and the GPS data, whatever information that they gleaned from the mobile servers were showing that she wasn't there. Other people moved it. So sometimes the cell phone can be your worst enemy. Sometimes it can set you free. And that is it for the show today, my friends. I want to thank all of you who had great questions today. We're going to hop on Clubhouse here in a minute, but let me go through and thank those of you who do support the program. We've got a lot of you. We've got Mary Jankovic. We've got Chairman of the Board. We've got Al Huber. Big thank you to Ma Fox. Big thank you to Miss Faith Joy. We've got Socially Troubled. We've got The Mariner. We have D. Sudlow. We have Jeremy Matrita's always in the house. We got Want to Know, Drew. We have Danny Girl. We've got SF Bob. Who else is going on? We got Aloe Wishes. We have Fang number 3. And we had a new person sign up. What's up and welcome, Jared Harding. We're excited to have you on the program and joining us over on Locals. Recently, we also had E to the. We had Danger Mouse Girl. We had News Now Wyoming. Saw many of you today, including JBone86. And we're just grateful that you are supporting the program and helping us to build a community where we can have real conversations, some of the stuff that we can't necessarily talk about on some of the other platforms. If you're not already over on Locals, go on over there and join us. We have some great things for you to download when you do. Get a copy of my book. It's called Beginning to Winning. There's a free PDF over there. You can also grab a copy of the slides. Miss Faith is going to post those shortly after the broadcast is over. We have some impeachment documents. If you feel like impeaching anybody in your local government or federal government even, just go impeach the hell out of them. Then we have existence system documents, which you can grab, which is a little personal productivity system over there. You can check that out. We share links throughout the day, and the real reason to be there is the great people. We have awesome people over there, many of whom you heard from today. They were asking fantastic questions, and so it's good for you to go meet other people. You know, get out of your Facebook bubble, get out of your YouTube bubble. Go on over to Locals and get to know some really interesting people in this world, because that's what it's all about. And so before we sign off, I want to thank a couple people for a couple things. So I got this delivered to the office today. So it's the Donald Duck, Take Quack America. And I wanted to just give a shout out to the person who sent that along with a card. I don't know where it came from, but thank you for sending that over. Another big shout out for this. These are bitchin' baklavas, all right? And they are outstanding, okay? Now, they're made in San Francisco, California. They're delicious. So check them out, right? Now, they're not paying for sponsorship or anything like that, okay? YouTube, don't flip out. But they're just really good. And these people have sent me some nice things. I know many of you show your support by going over to locals.com. Others just, that's not for them. And so sometimes they send some nice stuff to the office. And I just wanted to say thank you. I've also gotten some very nice notes, letters, and emails. And some of those things I can't physically respond to all of them, but I am grateful for them. I mean, they really mean the world to me. Many of you have sent very nice cards and very nice things. And so thank you to all. If I don't acknowledge you right away, I do get the things that you send. And I'm grateful for them. I mean, it really lights my day up. And so thank you for those things. Thank you for everybody who was here and a part of the broadcast today. We're going to be, before I sign off, remember, I am a criminal defense lawyer. That's what we do. That's my day job. You know, everything we talk about here is sort of, related to my passion, which is about helping good people who've been charged with crimes. We help people with DUIs, drugs, domestic violence, any felonies, major, minor felonies, traffic violations, clearing up old mugshots, removing arrest records, setting aside convictions, getting your life back, being able to vote again, possess a firearm, and go apply for federal benefits, and just living again. So we help people do all of those things. So if you happen to know anybody in the state of Arizona who has been charged with a crime, we would be honored and humbled if you send them our way. We will make sure they leave better than they found us, because that's what we're passionate about doing. We have a great team here. We offer free case evaluations. So give us a call if you need some help. And that's it from me, everybody. I'm going to hop off right now. We're going to go on to Clubhouse. If you want to be on Clubhouse, if you need an invite, we got plenty of them. Send an email over to us at tips@rrlawaz.com. Miss Faith is back there, just firing those off as soon as they come in. And we're going to talk there for a little bit. It's a great platform, so come join us. Otherwise, we'll see you back here tomorrow, same place, same time. It's going to be 5 p.m. Arizona time, which is Mountain. Then we have 4 p.m. on the West Coast for those of you in California and beyond. We have 6 p.m. Central in Texas, and then we have 7 p.m. on the West Coast for Florida man, Florida woman, like we talked about today. And I hope to see you all back here at that time. Have a wonderful evening. Sleep well, and bye-bye.